Stare decisis is the bedrock of the English common law, inherited by the US and many other nations. It's a Latin phrase that means to stand by things decided, and it's the principle behind following case precedents. I think it has a major issue, and I'd like to outline that today. My name is Buck Kansas. If you like the video, please like it and subscribe, and please comment anytime you think I'm wrong. There are two types of stare decisis. There's vertical stare decisis and horizontal stare decisis. With vertical stare decisis, this is the idea that higher courts make binding authorities on lower courts. So a trial court has to listen to the opinions written by the appellate court and the Supreme Court. The appellate court has to listen to opinions written by the Supreme Court, and the Supreme Court doesn't have to listen to anyone if it doesn't want to. Its own opinion is all that's controlling. This is a good system. I like this a lot. It gives a unity to our system of governments that wouldn't be present if we ignored it. So if the trial courts could ignore Supreme Court decisions whenever they wanted, we'd actually have as many justice systems as we have judges, which isn't desirable. So I like vertical stare decisis. I think it's a good idea. I don't have a better proposal. Horizontal stare decisis is the idea that a court should listen to its own past decisions, but it doesn't have to. In vertical stare decisis, we call the precedents controlling because the lower courts are controlled by the higher court decisions. In horizontal stare decisis, we call the precedents persuasive because they only have as much power as they persuade the current court that they should do what the old court did. I think horizontal stare decisis is pretty garbage. In particular, I think that its timeline is garbage. In theory, it makes a lot of sense because in theory, both old cases and new cases ought to be decided similarly. Old cases are protected by stare decisis because we've built laws, businesses, and customs on top of those old decisions, and overturning those means destabilizing those three things that we've built. That's probably not a good idea. Recent cases we ought not overturn. One, a lot of court cases talk about how the issue hasn't come to fruition. They want to see it percolate through the lower courts, see it be developed more. But two, the state of the country and the court is the same. So you'd expect that if the court makes a decision yesterday, it will make a consistent decision today. Each of those individually makes sense. It makes sense that old cases are important and ought not be overturned willy-nilly. It makes sense that new cases are important and ought not be overturned willy-nilly. My problem is the intersection of the two, because if you can't overturn old and you can't overturn new, when is good? It's not clear where that Goldilocks zone exists. So to help illustrate that, I want to talk about a seminal Supreme Court case, Planned Parenthood v. Casey. This is one of three important cases in the line of Supreme Court cases talking about abortion. You have Roe v. Wade, then you have Planned Parenthood v. Casey, then you have Dobbs v. Jackson. This one's the one in the middle, and the reason Casey is such an interesting case is because at this point, we're 19 years after Roe v. Wade, the composition of the court has changed, and now it is a mostly conservative court. And so the expectation was that Roe v. Wade was going to be overturned. But instead, the court said, some of us as individuals find abortion offensive to our most basic principles of morality, but that cannot control our decision. In Casey, the joint opinion decided that stare decisis requires Roe v. Wade to be upheld, even though a majority of the justices thought it was wrongly decided. In the discussion of stare decisis, the joint opinion lays out 4 reasons that you might overturn an old case. They say, well, the old case might be unworkable at this point. There might be sufficient reliance upon it that overturning it would cause damage. They look at whether the law has grown so far past that decision that it's now an anachronism discounted by society. And they look at whether premises of fact have sufficiently changed that the holding is now irrelevant or unjustifiable. Importantly, 3 of these factors indicate that a young case ought not be overturned, and one of them typically indicates that an old case ought not be overturned, but the court gives a different argument here. So, separately, the cases that indicate that a young case ought not be overturned, the unworkable standard, the newer cases, the more likely it is to be workable. A new solution is better fit than an old solution. Whether the law has grown so far past that it's now a doctrinal anachronism discounted by society, that's going to happen with time. An opinion that's important 100 years ago might not be important today and will grow less important over time. Change in premises of fact is going to happen over time. So those three weigh towards young cases being upheld by stare decisis, and that as a case ages, it's more likely to be overturned. The second factor they laid out, the one about reliance, typically that one would grow stronger with age, but the court kind of makes an opposite argument. It says that typically reliance is only about economic reliance, but in this case, reliance is about societal choice and societal structure, and that in reality, if abortion was overturned, the reliance interests aren't going to be slow to adapt. People are going to be able to make changes in their life immediately to address the fact that abortion is less accessible. So while typically this factor indicates that an older case has more reason not to be overturned, they modify the way they're looking at reliance to make it so that a young case also has reliance interests not to be overturned. The court then goes through two of the most important cases ever overturned, Plessy v. Ferguson and Lochner. Plessy v. Ferguson was separate but equal, an idea that we now understand is obviously bad, and then Lochner is a case that people know less about but is really important. Basically, that case decided that the federal government is not allowed to regulate many economic areas because of the rights of individuals to engage freely in contract. Notably, this meant that the government wasn't allowed to impose minimum wage laws or a 40-hour work week. In discussing why the court was okay to overturn there, Casey says that there were facts that the earlier court were not able to perceive, or that they weren't able to perceive correct understanding of those facts, and given sufficient time, the court was then able to perceive better. Applying that understanding to Roe, they said, neither the factual underpinnings of Roe's central holding nor our understanding of it has changed. So the court decided that Roe was too recent in time, that not enough had changed, not enough was different since they decided Roe, such that even though they disagreed with how Roe was decided, they were going to uphold it. Importantly, the court isn't explicit about the youth of the case being what causes stare decisis to be binding, but it follows from all their analysis. Notably, this lack of clarity leads the other opinions written in this case to not understand what the joint opinion's saying. Stevens writes the first concurrence/dissent, and he says the societal cost of overruling Roe at this late date would be enormous. Stevens thinks too much time has passed, that it's too late to overturn Roe. He agrees that stare decisis applies, like the joint opinion, but he thinks that the reason stare decisis applies is that the case is old. I think that captures the shape of the problem. Because the joint opinion thinks that Casey is too young to overturn, the first concurrence thinks Casey is too old to overturn. We see that same structure mirrored in the fact that Casey was the first time we got a substantive review of Roe v. Wade, and the court said, well, it's too early to overturn it. And then in Dobbs v. Jackson, the dissent argues, hey, it's this second time that we're looking at the substance of Roe v. Wade, it's too late to overturn it. This is an obvious shell game. At any point in time, you can argue that stare decisis defends a previous decision because it's too early or it's too late. There isn't actually a clear framework for how to determine if enough time has passed. And I bring this up with abortion only because the Planned Parenthood v. Casey decision talks about it so much. But you can find this in all variety of cases. It's honestly rare to find a dissent that doesn't talk about stare decisis being a problem for the majority's holding, because stare decisis, particularly horizontal stare decisis, is such a nebulous theory that you can make it say anything you want. So, what would I prefer? Well, one of the four dissents in Planned Parenthood v. Casey says that an important factor in a stare decisis analysis is how wrong was the decision on its face. I think that's right. I think the reason to overturn Plessy v. Ferguson, separate but equal, isn't that the facts and circumstances had significantly changed and that now the government plays a bigger role in people's lives. And so now it's actually important that we don't have separation, that we have integration in order to reach equality. No, I think separate but equal was wrong the day it was decided, the day after it was decided, and decades later when it was overturned. I think the principal reason to overturn Plessy v. Ferguson was that it was wrong. And I think this applies more broadly. I think there's degrees of wronginess. I think it's possible for a case to be wrong, but barely wrong, such that it's not even worth the court's time to reconsider. I think it's possible for a case to be more wrong, and so it's maybe worth the court picking the case up and examining it, but not substantially changing the rules that govern how cases like that are decided. But then I think there are also cases where the original decision was substantially wrong, and you meet a threshold where the court ought to overturn it. And I think that threshold isn't terribly hard to meet. That same dissent further says, surely if the court's power lies in its legitimacy, a product of substance and perception, the substance part of the equation demands that plain error be acknowledged and eliminated. And I think that's right. What's more, I don't think this would actually cause the instability that other people seem to be worried about, because it's unlikely that the same justice realizes they made a plain error. It will take time for them to realize their previous decision was erroneous. And, in fact, we see that here. 3 years after Planned Parenthood v. Casey, we got the case Seminole Tribe of Florida v. Florida. In that 5-4 decision, 2 of the justices who had signed on to Casey signed on to a majority opinion that said, when governing decisions are unworkable or are badly reasoned, this court has never felt constrained to follow precedent. 3 years later, after writing Casey that has so much discussion about how we don't need to look at the underlying reasoning to determine a stare decisis case, 2/3 of the same judges who signed on to that opinion said bad reasoning is a reason not to follow precedent. They changed their mind, and I'm glad they did. If we were wrong yesterday, we should acknowledge it and choose to be better today. We should do that both as individuals and in our institutions, because being consistently evil is worse than inconsistently good. I've been Buck Kansas. Thanks so much for listening to my thoughts. Once again, please like and subscribe if you can. It really helps out a lot. I cut a lot of the legal minutia that went into Planned Parenthood v. Casey. I tried to keep it from intruding too much. But if you want to go read it yourself, it's a pretty difficult case to read. It's 170 pages, and it has 5 different opinions. The first opinion, the one that's called the joint opinion, only has 3 of the 9 justices signing on to it. And then the other 6 justices write 4 opinions in which they concur and dissent in part. So the true holding of the case is a Frankenstein of what has majority support and what doesn't. Although I think they do a good enough job in that 3-person opinion outlining what the law is going to be going forward, and the first 2 concurrences acknowledge that they agree with those parts. But it's a little bit of a mess, although a very entertaining read if you have the time. Anyway. Bye!